My name is Goldman. I'm an attorney and founder, director of Goldman & Associates, a law firm in Michigan. Our firm has a primary focus on family law issues here. Today we're continuing our video series designed to educate the public, so please subscribe to our channel. Does cheating matter in a divorce, or more specifically, when does infidelity become a relevant factor in the divorce? Well, as you may have heard, Michigan's a no-fault divorce state. Well, what does that mean? That means a person can seek divorce without the need of demonstrating fault. So therefore, at least on its face, one might argue, well, cheating doesn't matter, because why would it? In other words, since we don't have to show a reason to ask the court for a divorce, why does it matter if one person cheated or one person didn't cheat? The answer is that with respect to getting the divorce, it probably doesn't matter. The question, though, becomes, does it matter for other things? And the answer is very much, yes, it does. It could matter, for example, as the court determines property division. It could matter as the court determines custody of minor children. That's why you always have to consult an attorney to find out what is the relevant factor involved. Not to mention, if cheating is established, while it may not contribute to getting your divorce, it sure may make negotiations harder. It sure may make the other side more entrenched in their position with respect to an ultimate property settlement. So, as we analyze the whole thing, I would say this: to get the divorce itself, in a vacuum, cheating doesn't really matter because we're a no-fault divorce state. But once we start bringing in the other factors, like a property settlement, for example, the court can take into account fault. A fault factor would be cheating. The question, though, that the court always grapples with is, fault is a factor to determine property division. So I suppose cheating might be one of those factors, but the fault has to be fault which proximately caused the breakdown of the marriage. In other words, you'd have to prove that the cheating brought down an otherwise healthy marriage. And more often than not, the cheating is not the cause of the breakdown of a marriage, but rather just a symptom of a bad marriage. So if that's the case, the court, unless it's persuaded, might not take it into account when dividing up the property. And even if it does, I will tell you that if you read the Michigan Court of Appeals opinions and the opinions that are relevant to the establishment of precedent here in our state, even in cases of egregious fault, cases where there's terrible cheating or terrible spousal abuse or drug abuse or God knows what, you never see a settlement that the court approves that's going to be 90% one person, 10% the other because of the fault. You don't even see 80-20. You might see 55-45. That's what you might see. Maybe 60-40. You're not going to see some huge swing in it because of a fault factor. So therefore, when you're going to decide, should we make the fault factor a part of this, you really need to consult with your lawyer, because it's going to be, you're going to have to weigh, you know, what's the ultimate price I'm going to pay? Yes, I may get extra out of it, but will it be worth the ultimate fallout from these allegations, which no doubt will result in allegations against the other person for whatever misdeeds they may have been guilty of in the marriage too. If you have any questions about your case, reach out, and we'll be glad to help you out.